is this, because these are standalone webinars that are being recorded, I have to do a little repetition of the background information for people. So bear with me, even though I know if this is not your first webinar, you know all of this already. So just bear with me on this. So CDAC, Communication Disabilities Access Canada, is a non-profit Canada-wide organization. We've been around since 2001. Our mandate is to promote human rights, accessibility, and inclusion for all people who have speech and language disabilities, and we use SLD on our slides for that, including people who use augmentative and alternative communication, or AAC. We have no core funding. We are entirely project funded, and therefore we have these are limited, time limited projects, and this project is funded through the Law Foundation of Ontario. We're an organization of speech language pathologists, of augmentative communication clinicians, legal professionals, accessibility consultants, as well as people who have speech and language disabilities. And depending on the project that we're doing, we bring different professionals together to focus on specific issues. If you're not familiar with us, you may want to check out our website. We put everything on our website. And so if you go onto the homepage and then go into our projects, you'll be able to see lots of different topics that we've been working on over the past 15 years, and you can get more information and resources there. As I say, this particular project is funded through the Law Foundation of Ontario. And that project is linked to Connecting Communities, which is operated by CLEO, Community Legal Education Ontario. So we'd like to acknowledge Catherine Hunter from the LFO and Vivian Green from CLEO for supporting this. It's important that you know that we have participants from across Canada. Most people are from Ontario, but we have other provinces represented as well, and that the participants are coming with different backgrounds to all of our topics. The main group, majority of people, are speech language pathologists. However, we also have people with speech and language disabilities on the line and certainly attending this webinar. We have family members, we have students, we have social workers, healthcare providers, as well as legal professionals. So we can't get into specific details for one group. We're trying to meet everyone's needs. We're not going to be successful in doing that, but we're doing our best to meet as many needs as possible. Our presenters today, Brendan Poran, who's a lawyer, and Brendan's business is, our organization is Poran Law. It's based here in Toronto, and they specialize in legal services for people with disabilities, family members, and organizations. We're also joined by Megan Hines, who's an occupational therapist. Megan's worked on a number of projects with me. She has a very strong background in working with people who have speech and language disabilities and in helping them to transition from family homes into the community. Megan's currently, as I say, working in a hospital, and she's working with people with chronic, children and youth with chronic disabilities and illnesses. So we welcome her. I'm Barbara Collier. My background's in speech and language pathology, and I'm the executive director of CDAC, and I also manage all of our projects. In this webinar, as I say, this is the third one, we will be providing the legal information that is pertinent in Ontario. Now, we know that it may have application in other areas, there may be similarities, but the whole focus of this is not so much to provide a whole legal dissertation on everything, but it's to get the conversation started between the legal community and the community of people with speech and language disabilities and the people who support them. So it's the start of this conversation. All our webinars start at 7. We are recording them and we will be putting them on our website. That is the link for it. But I'll be sending out the links once they're up. We're probably going to have the first 3 webinars up by the end of next week when Steve comes back from his vacation, and then the other ones we will have 2 weeks after we have given them. So at this time, we did the foundation of communication, of access to goods, services, and opportunities. That's really important because that's the foundation and the legal basis for a lot of the other stuff that we're talking about. If you haven't heard it, you'll be able to go back to the recorded version. Last week, we talked about consent to treatment for people who have capacity. Today, we're talking about substitute decision making. Next week, we're going to be talking about personal support services. And on the Tuesday, just want to flag that, June the 14th, not the Wednesday, June the 14th, we're going to be talking about abuse and crimes within the caregiving context. And that'll be with Pamela Cross, who's a lawyer who's worked with us on access to justice. Before we get into today's webinar, I want you to know again that this is grounded in reality and in stories and experiences of people who have speech and language disabilities and in family members telling us about their experiences. And you can type your questions as you think of them, or you can wait till the end. We're going to try and finish up by 8 o'clock and then do questions and everything until 8:15, and then we're all going to run off and watch the Raptors this evening. Win, they are going to win. So the agenda, we're going to talk about substitute decision makers, who they are, what their role is, what their responsibilities are, the different areas of decision making. Brendan's going to talk about a hierarchy of substitute decision makers, or SDMs, how to appoint a substitute decision maker, and using a substitute decision maker. So that's the agenda for today. And now I'm going to pass you over to Brendan. Brendan.
Well, thank you very much, Barbara, and welcome everybody to our webinar on substitute decision making this evening. As Barbara mentioned, I'm going to start off with a bit of an overview about substitute decision makers. A substitute decision maker is a person that makes decisions for another person, and that's how the term is defined in a publication called A Guide to the Substitute Decisions Act that's been put out by the Attorney General of Ontario. If you're interested in having a look at that guide or reviewing it, you can simply Google it and it'll pop right up. A substitute decision maker's authority may be triggered under one of a number of statutes or a number of laws, and we've listed the laws here for you. The first is called the Substitute Decisions Act. The Substitute Decisions Act sort of governs the rules and regulations that apply to guardianship appointments and powers of attorney documents. The second is the Healthcare Consent Act, and as the name implies, the Healthcare Consent Act relates to decisions that are made in the healthcare context, and we're going to chat a little bit more about that in a few minutes. The Mental Health Act, specifically applying to situations where somebody may be a patient at a psychiatric institution. And finally, the Personal Health Information Protection Act, and that deals with privacy legislation here in Ontario. We're not going to get into that too much during this webinar. Authority to act as a substitute decision maker is usually triggered upon incapacity. So what that means for those of you that were with us last week, we sort of discussed a two-step process when it comes to legal decision making. The first step always being whether or not the individual themselves is able or capable of making their own decisions. And if that person is able to make their own decisions, if that person's capable of making their own decisions, then that is their right to make a decision, and nobody else has that right to take away from them. However, if the person is deemed incapable of making their own decisions, usually that is when the authority of the substitute decision maker is triggered. So it's usually triggered again upon the individual's incapacity, and again we'll get into that a little bit deeper as we work through the webinar. So what is the role of a substitute decision maker? And I'm sure you've picked up on this, but anywhere that you see a reference to SDM in the slide deck, that refers to substitute decision maker. So generally speaking, the role of the SDM is to make decisions for another person, usually in situations, again, where the person is incapable of making the decision themselves. In Ontario, we sort of have two broad areas of legal decision making, and the first one dealing with a person's property, so their real property, their finances, etc., and the second dealing with the individual's personal care matters. So anything related to healthcare decisions, hygiene, nutrition, safety, shelter, and clothing. And so the role of the SDM is really to make decisions for the other person within these two contexts. Now, what are the responsibilities of an SDM? And the responsibilities are quite exhaustive and are sort of identified in the various pieces of legislation. But generally speaking, the responsibility is to ensure that autonomy is maximized, and that the individual is involved in making decisions. So if the individual may not be capable per se of meeting the legislative thresholds, the general tests that we spoke about last week of understanding and appreciating, but they may still be able to provide some input in the decision-making process. And so it's a responsibility of the SDM to ensure that the individual is involved. The SDM must act in accordance with the individual's documented wishes and or prior capable wishes. So if I'm my spouse's SDM and she has prescribed or documented wishes in a written document, or even if she's articulated those wishes and hasn't written them down, I am legally obligated to carry out her wishes. Only if she has not documented or expressed these wishes do I then switch into or approach the decision-making process in terms of her best interests. So I'm just going to sort of recap that. If there are documented or expressed wishes, and I'm legally authorized to act on those wishes. If there aren't, then I'm looking at acting in the individual's best interests. Okay. And I must consult with a person or persons who know the individual well. So if I'm trying to ascertain the grantor's wishes, or if I'm trying to ascertain best interests, then I've got an obligation to consult with other people who know the individual. Okay, two broad areas of decision making, and I touched on just a minute ago. So again, the first one deals with a person's property, their money, their ODSP, which stands for the Ontario Disability Support Program, their RDSP, or their Registered Disability Savings Plans, or other forms of property such as real property. Personal care again covers 6 areas: healthcare, nutrition, shelter, clothing, hygiene, and safety. And so the idea here is that in the Substitute Decisions Act, one of the laws that I referred to a few minutes ago, the act is sort of kind of divided in half, with the first half dealing with a person's property and the second dealing with an individual's personal care. So the question then becomes, who can act as a person's substitute decision maker? And again, we're assuming here that in the majority of cases, the person has been deemed incapable of making a decision themselves. So we call this a hierarchy of substitute decision makers when it comes to making decisions on behalf of a person with respect to their property. And you can see that the list is fairly short. So we've got the guardian of property that is sort of at the top of the hierarchy. So if someone has, and we'll talk a little bit more about guardianship in a minute, but if someone has been appointed by the court of another person's has been appointed by the court as a guardian of another person's property, or has gone through a process with the public guardian and trustees office, then they would have the legal authority to make decisions on the individual's behalf, and that would sort of trump anybody else's decision-making authority. If there is no guardian in place, keeping in mind that the majority of people do not have guardians for property in place, then if an individual has been authorized by way of a continuing power of attorney for property, that person, the person who's identified in that document, would have the authority to then make decisions on the grantor's behalf. And we are going to get into powers of attorney for property a little bit more in just a minute. Now, when we look at the hierarchy of substitute decision makers for healthcare related matters, so healthcare related matters including consent to treatment, admission to long-term care homes, and personal assistance services, you can see from the slide here that the hierarchy is a little bit more extensive. So we've got the guardian on top again. Now, this is not guardian of property. This is guardian of personal care. We've got second, an individual appointed by way of a power of attorney for personal care. Third, we've got a representative appointed by the Consent Capacity Board. Now, if there isn't any guardian, if there's no attorney for personal care, and if there isn't a representative appointed by the CCB, then family members come into play. And so first, we've got the spouse or common law partner of the individual. Second, we've got a child or parent, so they rank equally. And when we're speaking about a child, we're speaking about a child that's at least 16 years of age. Third, we've got a sibling, so a brother or sister. And fourth, we have any other relative. Okay. So let's sort of go through these one by one, and again, we're going to be focusing on sort of the healthcare side of things for the most part throughout the webinar. Although we are going to touch on the power of attorney for property as well. In terms of guardianship, a person must be found incapable of managing their property and or consenting to personal care matters in order for a guardian to be appointed to make decisions on their behalf. So I just can't go out and apply to become guardianship for a family member if they still have the capacity to make decisions themselves. That can't be taken away from them unless a formal capacity assessment has taken place and a capacity assessor has found the person incapable of making their own decisions. With respect to the process involving becoming a guardian for personal care, that process, a person can only be appointed by way of the court. So a formal court application has to be filed, and the court has to ultimately determine that yes, this person is incapable, and secondly, that the applicant is a suitable guardian for carrying out the role of a substitute decision maker. On the property side of things, a person could be appointed by the court, or there's a statute, what's called a statutory guardianship process that involves the Ontario Public Guardian and Trustees Office. So in other words, if the PGT's office has been appointed as an individual's guardian of property, there is a process that family members can go through outside of the court process to have that guardianship transferred over to them. Okay. It's important to note that anytime a guardianship application is launched, that there is a legislative requirement that requires the courts to consider what we call the less restrictive provisions. So in other words, if there is an alternate means of substitute decision making or supporting the individual in making a decision, then the legislation precludes a finding of incapacity and a guardian being appointed to make decisions for that person. So an example of this would be, let's say that a guardianship application was made by an individual to become a guardian of one's personal care. If that individual already had a power of attorney in place, authorizing a substitute decision maker to make decisions on their behalf in the event of incapacity, that would be considered a less restrictive provision. And so the guardianship application would not be successful. So that was guardianship. Moving down the hierarchy, let's talk about powers of attorney. So first, we're going to talk about a continuing power of attorney for property. A continuing power of attorney for property is a document that gives someone else the authority to act on your behalf while you are alive with matters relating to your property. So it's important to note that powers of attorney are in place when you're alive, and once you pass away, the powers of attorney do as well, and your will takes over. Last week we sort of discussed tests related to managing one's property and consenting to personal care decisions. There are capacity requirements related to the granting of power of attorney documents as well. So there's kind of a test to determine whether or not someone is capable of granting power of attorney. And these factors that we've put here on the slide is taken right out of the legislation. So in order for me to be capable of granting power of attorney, I must know the kind and value of my property. So what do I own and how much is it worth? I must be aware of any obligations that I have to dependents. So perhaps to my spouse, to my children, is anyone reliant on me? Do I understand and appreciate those obligations? I must understand and appreciate the authority of the attorney. So by signing the document, can I appreciate what kind of power, what kind of authority the person now has over my assets and over my income? I must know that the attorney must account for all of their actions, which is very important. I must know that if I'm granting power of attorney, that I also have the option of revoking it if I no longer want that power of attorney in place, or if I want to change my attorney. I must appreciate that by handing over this authority, that the value of my assets may decline, depending on how they're managed by the attorney. And I must appreciate that the attorney could misuse the authority. So, signing a continuing power of attorney for property provides the individual that you're naming, provides the attorney with a great deal of power over your assets, and often, and unfortunately, we sometimes see those that authority and that power being misused. So I have to appreciate the magnitude of the authority that I'm providing to the attorney, and appreciate the fact that the attorney could misuse that authority. So next we'll talk about the power of attorney for personal care. Like the power of attorney for property, the power of attorney for personal care has its own capacity requirements. This document gives someone the authority to act on your behalf while you're still alive with matters relating to your healthcare, nutrition, shelter, clothing, hygiene, and safety. Now, the capacity requirements to enter into one of these documents are a bit lower than they are for the power of attorney for property. The two requirements are that the individual has the ability to understand that the attorney has a genuine concern for the person's welfare, and appreciates that the attorney may have to make decisions for that person. So do I understand that the person cares about me and has a genuine concern for my well-being? And can I appreciate that the person may be placed in a situation where they would have to, or he or she would have to, make a decision on my behalf if I am deemed incapable of making that decision myself? And once I can meet those legislative thresholds, I would satisfy the capacity requirements for entering into a power of attorney for personal care. So then we again move down the hierarchy, and we've sort of come to the end of the hierarchy on the property side of things. But as you may remember from a few slides ago, the hierarchy on the dealing with healthcare related decisions does extend a little bit more. So the The third level referred to a representative being appointed by the Consent and Capacity Board. And this can be done through a couple of different applications called a Form B and a Form C. So a Form B is a request for a representative. So this is an application to the CCB by a person who is found incapable of consenting to treatment decisions, admission to a long-term care facility or personal assistance service to have a representative appointed to give or refuse consent on his or her behalf. So this would relate to, let's say, a specific type of treatment, such as antipsychotic medications or admission to a specific long-term care facility or perhaps to personal assistance services. So what this allows an individual to do is apply to the board and say, I want my friend or I want my relative to be able to make decisions for me on my behalf when I am incapable of doing so myself. A Form C differs in that it is a request to be a representative. So it's an application to the CCB to be a person's representative that has been found incapable of consenting to treatment decisions, admission to long-term care facility, or personal assistance service. So with the Form B, it's the incapable person that's applying to the board, asking the board to appoint a representative. With the Form C, it's not the incapable person. It's the proposed representative that's applying to the board, asking for the authority to make specific decisions on the individual's behalf. Okay, and I'll turn it back over to you, Barbara.
Thanks, Brendan. Wow, there's so much there, and I don't even know where to start with it and where my questions are going to come from. I'm interested to hear what everyone has to say towards the end of the webinar and what questions and experiences that they've had on this topic. But when I think about substitute decision makers, it makes me wonder about what our role is there. And you said earlier that there has to be some involvement in decisions to maximize autonomy and involve the person in decisions as best as one can. And that makes me think you have to have communication in order to do that, and the role that many of us have in supporting people to communicate with their supported decision maker. And there's a few things. I think, first of all, I've been quite divorced from this topic and maybe naive about it. I remember at one point asking staff in a developmental service organization if they were aware who the decision maker was for the people that they supported. And across the board, they didn't know, which I thought was kind of interesting. I also asked people who have speech and language disabilities whether they made their own decisions or if family members did it. And across the board, they always said that their family member did, but hadn't actually thought through the implications for some of that. So I think it's something that we have to be, I don't have the answers on this, but much more aware of. And I think we can play an enormous role in providing appropriate communication accommodations and supports with substitute decision makers. In all the years, and I've been working for a long time, I've only been asked, well, I wasn't even asked. I actually volunteered to support a substitute decision maker understand what the person's preferences are and who that person was and how they communicated. The person was at a pre-intentional communication level, non-symbolic, but the person could still make choices and preferences in their lives. And I really believe that decision making can be very informed by people's choices and by their expression of their preference and rejecting things that they don't want, their body language. So I think that there's a role that we already play, sometimes, most of us, in helping families and helping other support staff around people understand somebody's communication. And I think that has to include supported decision makers. And that's where in this discussion, I see a major gap, certainly a gap in what I've been doing, and I'm interested to know what other people think of that. I think we can make recommendations on how to facilitate the person's participation in the process, no matter what and at what level. And I think that we can state that the client may require accommodations within that process itself. Again, I think it's coming down to when we write reports, putting in place what somebody needs to consider in terms of accommodations and supports around decision making. I'd like to, at this point, hand it over to Megan, who's got some questions and also has experience in a number of issues around this area. Megan. Are you there, Megan? There's a little gap, I think, when you come on. Can you? Okay. Megan, are you there? No. All right. I'm going to ask Megan's question, and maybe Megan will get back on fairly soon. Oh, she's coming in again. So let's go. Brendan, I'll ask you the question. We were asked, when would you advise someone to get a power of attorney, and how would somebody go about choosing and appointing an attorney?
Sure. So I think anybody who is able to grant power of attorney should have one in place. As you can see, especially on the property side of things, where the hierarchy of the SDMs is very short, we really only have a guardian and then an attorney appointed by way of a power of attorney. Those are the only two sort of, options that we have when it comes to appointing a substitute decision maker. As I mentioned, very few people have guardians in place. Nobody really wants to go to court to confirm a person's incapacity and then, be appointed guardian. I mean, that really does involve taking away all of the individual's decision-making rights. And so, it is very important to have a continuing power of attorney in place for property, in order to ensure that someone is there to make decisions on your behalf if you're unable to make them for whatever reason. For example, if on my way home I get into a car accident and I'm in the hospital and I can no longer manage my property, then I want someone to have the authority to pay my bills and to manage my assets and to take care of my dependents. Without that power of attorney in place, someone would have to go through the arduous, expensive, and frustrating process of guardianship, which is should only be considered as a very, very last resort. On the personal care side of things, you see that there is a more extensive hierarchy that includes family members. Many individuals may not want their spouse, well, maybe not their spouse, but maybe they may prefer one parent making a decision over another, or one sibling making a decision over another, and having a power of attorney for personal care in place is the only way to do that. So I would highly recommend that everybody who's able to have a power of attorney for property and personal care in place to do so. How would someone go about choosing and appointing an attorney? Well, again, we have two documents. We've got the one relating to property and the other relating to personal care. On the property side of things, I mean, you are looking for someone who is able to manage money efficiently and would be good with accounting and would be conscientious when it comes to record keeping. Obviously, somebody that you trust is first and foremost, because again, you're handing over authority to someone else to manage your assets and liabilities. On the personal care side of things, I mean, these decisions are a lot more personal. They relate to consent to healthcare treatment. They relate to where you're going to live, what you're going to wear, what you're going to eat. So obviously, someone that you trust has a genuine concern for your well-being when it comes to your personal care matters.
Thank you, Brendan. Our next question for you is, once a person has an attorney in place, what should they do?
Well, I think one of the most important things is to let third parties know that these power of attorney documents exist. So with regards to your power of attorney for personal care, you can let your family doctor, specialists, your CCAC manager know that you have a POA in place, and provide them with the person's contact information. It's very, very important though, when you're doing this, that you do convey that you are still perfectly capable of making your own decision. And so that the attorney for personal care should not be contacted unless a decision has to be made and you yourself are unable to do that. And I should sort of bring up another important point when it comes to a continuing power of attorney for property that I neglected to mention earlier, and that is a continuing power of attorney for property can be set up in such a way where the authority granted to the attorney is triggered as soon as you sign that document. So in other words, I give instructions to a lawyer to draft a power of attorney for property. I sign it, and whoever I've named in that document now has the authority to act on my behalf. The second option is to trigger that person's authority only upon your incapacity. So if you only want a person to step in and manage your property, if you are deemed incapable of doing so, then your power of attorney document has to specifically state that. A lot of the generic forms, a lot of the forms that you can download on the internet and that sort of thing, sort of are drafted in such a way where they become effective upon signing. So if that is not your wish, you've got to be sort of cognizant of that and ensure that accurate wording is in there to ensure that the attorney's authority is only triggered upon incapacity. So this relates back to what you should do. So when we're talking about a continuing power of attorney for property, you may want to file a copy with your bank, or with ODSP, or with the financial institution that holds your RDSP. And you want to inform them again that the power of attorney document is either effective upon your incapacity or upon signing, depending on what it says. Carry a card or have it programmed into your device, so you could have a copy of the power of attorney document stored electronically in your tablet or in your smartphone. Make sure that your attorney is aware of your wishes and beliefs about care situations that are likely to come up, and know how to ask questions specific to the disability community when asking about treatment options, i.e. supportive housing, services, etc. So this goes to the point around the attorney being obligated to act on your prior capable wishes. You want to ensure that those are documented, or that you've expressed those wishes to the attorney. Because if you haven't, then the attorney is going to simply be acting in your best interests, which may be inconsistent with your prior capable wishes. And ask your attorney to store a copy of the document in a safe place that they can easily access in an emergency situation, or inform them where a copy is stored. And I think that goes without saying. So if you're naming somebody as your attorney for property or personal care, you definitely want to either give them a copy of that document, or if you're uncomfortable doing so, you don't want them to see the document until you do become incapable, then let them know where they can find it, which may be a specific filing cabinet or at a lawyer's office. But it's important for them to have access to the document if they need to make a decision on your behalf.
Thank you, Brendan. We seem to have lost Megan. Yes. Anyway, we'll continue here. The question now is, we've heard from people who want to know if they can change their substitute decision maker, and how does one go about changing a substitute decision maker?
Yes, absolutely. People can change their substitute decision maker as long as they have the capacity to do so. So remember when we went through the capacity requirements to grant a POA for property and a POA for personal care, as long as the individual meets the capacity requirements to give a power of attorney, that also means that they are able to revoke any power of attorney document that they've already put in place. So there's no special form to revoke the authority that you've granted upon somebody, and a lawyer isn't required, but the revocation must be in writing and it must be witnessed by a couple of people. It's a good idea to give a copy to anyone that has a copy of a previous POA. So, in other words, you want to inform third parties such as banks and hospitals and doctors' offices that you've revoked the person's authority, and you want to make sure to destroy and shred any old power of attorney documents.
Thank you, Brendan. A number of advocates have expressed concern over substitute decision makers that they feel do not have the best interests of the person in mind. And one example is a family member who makes serious healthcare decisions without ever communicating or consulting the person with a communication disability. If we see that happening, what can we do about it?
Sure, that's a good question. So, I mean, obviously, the advice here is going to vary depending on context and the particular facts of each case. But it goes without saying that if the conduct is serious in nature and potentially involves criminal activity, then contact the police, right? If any kind of fraud is involved or abuse or neglect, then contact the police. If appropriate, speak with the person, the team, and explore options. So maybe there's a miscommunication when it comes to your prior capable wishes. Try to speak with that person or members of the individual's support network. You can contact the Public Guardian and Trustees Investigations Unit. Again, if you feel that there are serious adverse effects that relate to the behavior. The PGT's office has an investigation branch, and again, depending on the facts of the case, they may investigate. You can file an application with the Consent Capacity Board to, either have somebody appointed as a representative for specific matters related to healthcare, or you can apply yourself to be the representative of another individual. And if you have the capacity to do so, then you want to revoke the power of attorney document and perhaps consider authorizing somebody else to act as your SDM.
Okay, all right. We see a lot of that, by the way, Brendan, where we would question.
Okay.
And it goes back to what we were talking about last week, which was so many capable people not being consulted, and then and just having no communication occurring. So it's much.
Yeah, and again, and that's an important piece again, Barbara. Just to sort of reemphasize the fact that it doesn't matter. Let's say if you have a power of attorney document in place, that doesn't take away your right to make your own decision if you're capable of doing so. It's important to note that with these documents, with these power of attorney documents, especially with the documents related to personal care, the authority is only triggered upon your incapacity. So if someone is ignoring you, or if you're and you're perfectly capable of making your own decision, then you want to do everything that you possibly can to assert your own authority.
Very difficult for a lot of people who can't speak.
Yes.
Very, very challenging. But that's why I think that we need to be having these conversations, because I see a huge role for those of us who support people with speech and language disabilities to prepare them to talk to the families, to be on board with this. So I'm really appreciating this information. It's making me aware of lots of loopholes that I think we need to focus on.
Good.
We have a question here. What does the law require a substitute decision maker to consider when making a decision?
Sure. So I sort of touched on this a little bit earlier. So first of all, prior capable wishes must be considered. So that's first and foremost. So again, if they're documented prior capable wishes, or if they've been expressed orally and people are aware of them, then those have to be respected. If there is no prior directive, then best interests must be considered. That's sort of the threshold. Consult with the individual as much as possible, because again, they may not meet let's say the level of understanding and or appreciating in order to make the decision, but they may still be capable of participating in the process and providing some input. Discussions with people who know the person best and can provide input on the person's wishes, beliefs, and preferences. So, consult support networks, consult family members and friends and individuals that engage with the person on a regular basis. Speech language pathologists play a significant role in interpreting a person's communication and behaviors. So again, this speaks to involving the individual in the process of making decisions. Communication should never be a barrier. So speech language pathologists could assist with interpretation and communication. And you've got to sort of balance quality of life and the potential risk to the individual as well when making decisions, and that isn't always easy. And so again, consultation with other people in the person's life is very important.
I'd be interested to hear what the participants have to say, what their questions are about prior directive. If there's no prior directive or a prior directive has to come first. I think we see a lot of people who say one thing 1 minute and say, well, I wouldn't want this to happen, or I wouldn't ever authorize that. And then in the situation, appear to be okay and have a very different a quality of life, even though the situation is there. You're saying that their prior directive would trump that?
Prior directives would trump. Yeah, I mean, if the SDM is aware
Yeah.
of a person's prior directives, their prior capable wishes, then that is what those wishes must be executed.
Hmm. Interesting. Interesting in light of where we're going to with legislation around C14.
Mm.
Anyway, interesting. Um, here it is, advanced directives. Can you give your power of attorney advanced directives? I beg your pardon, here it is. For example, I'm doing what Megan was supposed to do, so I'm not even aware of what's coming up. For example, if the person never wants to have a feeding tube and states that they would choose the risk of choking, would that hold?
Hmm. So this is a tricky one. I mean, it kind of depends. So, I mean, if this is a specific wish, then I would suggest that that wish be incorporated into the power of attorney for personal care. Now, it would be up to the SDM to respect that wish and to provide direction to the healthcare practitioner that is consistent with the individual's documented wish. But whether or not the healthcare practitioner decides to respect it may be based on the situation at hand. Like, is the risk too great to respect that wish? Would it trigger an emergency situation where, as we all know now, consent isn't required to act? So, I mean, it's hard to sort of give a definitive yes or no answer here, but I think the point is that a person can give advance directives, and it's very important that those advance directives be documented if the grantor wants them respected.
Thanks, Brendan. And I see Megan is back, and I wonder if she's got
Hello.
audio.
Can
Brendan,
you hear me?
yes, we can hear you.
My apologies, everyone. Our home internet went down and we had to call Rogers. So right at the moment I was just about to speak, it just dropped right out.
Megan,
So,
I must say I'm impressed that you got back on so quickly.
oh, you know what? I don't think Rogers did anything. I think it came back on its own while we were on the phone. So
Anyway,
I'm
it's good
hoping it holds.
Megan,
Um,
we're talking about advanced directives. Um,
yes.
did you want to add to anything here? You want
I would say that the most common case where people do this is when they do have a degenerative condition where they know the trajectory of what's going to happen somewhat. That may be one situation where someone might want to put an advance directive in place. Um, But yeah, it is something you would want to consider very carefully because, as you said, Barbara, there's a lot of people who assume that at a certain level of disability or a certain type of condition that they would not want treatment or that they would want to prolong their life, and then once they're in the situation feel differently about it. So it is a tricky sort of subject to kind of consider with that. Yeah.
Thank you. Thank you. And I think we talked last week about physician-assisted dying, and that's linked in with, I know at this point, well, I think all the legislation has been stalled, if I'm correct, Brendan, but that the bill did not include advance directives at all in it. Brendan, do you know where the bill is at right now for this?
That's my understanding as well. I'm not sure exactly where the bill is at, but I do believe that it has been stalled as well, Barbara. But fairly certain that there aren't any provisions included in the bill related to advance directives. That would be scary.
Yes, yes. Megan, the next question is from you. Do you want to take it over?
Yeah. So definitely assisted dying was a topic that people were concerned about, particularly whether or not there's SDM could make decisions about physician-assisted dying. There were a lot of fears that people had that a sibling, for example, could end up being an SDM who didn't necessarily have the same beliefs about disability or understand quality of life for the person themselves, and they were concerned about whether or not there are safeguards in place that protect people with speech and language disabilities specifically, and whether or not this is going to be a part of that legislation.
And as we say, it's stalled right now, and but there's lots of recommendations in place or safeguards. As I think I mentioned last time, the vulnerable persons standard is there, and we're a group of, I think it's about 60 organizations, disability organizations, are really pushing for that. But at this point, we're not sure what's happening with that legislation at all. Megan, the next question, would you like to frame it for us?
Oh, yes. So I do work at a pediatric facility, and parents are often surprised that for a child or young adult, that they might not automatically be able to make all of the decisions. They often believe that there's an age of consent, usually around the age of 18, and so they're often surprised when they find out that that's not necessarily the case. Say a 16-year-old could be capable. So do you have any comments in terms of what we could be doing to better prep our patients and families, and what the law actually kind of says around that, to clarify?
Sure. So I think we spoke about this a little bit last week, and there may have been some confusion. So for that, I apologize. What we were trying to convey was that there is no real age of consent per se when it comes to consenting to healthcare treatments here in Ontario. So each situation is assessed on a case by case basis. What is the age of the person? What does the situation or what does the proposed treatment involve? What's the maturity of the individual? And so those are the factors that kind of go into the healthcare practitioner's assessment as to whether or not the individual is capable of making their own healthcare decisions. So there is no minimum age. There's sort of an assessment that's done on a case by case basis. However, at age 16, everybody in Ontario is presumed to be capable. There's this presumption that a person is capable of making their own decisions related to healthcare treatments or related to healthcare treatment, unless there is specific evidence that indicates otherwise. Okay, so in other words,
and I would say, I would add to that. Yeah.
You go ahead, Megan.
Oh, sorry. I would add to that as a professional, I think your best bet is to document the process that you went through for capacity and consent. Almost regardless if you're dealing with a young person, just to show your reasoning should it ever come up or be questioned as to why you felt the person was capable or incapable of making the particular decision. So if you look in the resources for this webinar, the College of Occupational Therapists of Ontario has a great checklist or guide to how you should be documenting capacity and consent. And I noticed that none of the other colleges or in professions for various other professions kind of had that type of checklist, but it is helpful in case that is ever questioned as to why you made a decision one way or the other with a particular patient and a particular treatment.
What sort of things are on that checklist, Megan?
Well, it's basically that two-step test, whether or not the person understood the nature of the treatment and whether or not they understood the implications of the treatment. So I think for your individual practice, if you're doing something that's fairly standardized, like a seating assessment, and so the intervention is the same for every client that you have, you may want to come up with a standard way that you explain it and maybe a standard set of questions for people that you think you have reason to believe that there may be a capacity issue there, whether or not that's because of age or whether or not the person expresses some confusion when you're talking to them. And even just for patient education, it's a good idea to ask those questions anyways to make sure that the person understands what's happening in your assessment from go, right? So yeah, it's that two-step process essentially is a big part of that checklist.
Megan, you were missing in action there for a little while.
I know, I'm so sorry.
You absolutely. But I wanted to make sure that you had an opportunity to tell us about your experiences around substitute decision makers. Are there any key things that you would like to tell us about before we turn it over to everybody?
Yeah, I think the key thing that struck me is that people were often not really aware of what this hierarchy meant. And I think the power of attorney for personal care can be really empowering for people that have difficult relationships with their family members or are nervous about what kinds of decisions their family members might make or if they'll act appropriately. And I think it's a very empowering tool for people to choose whomever they want, family or not, to be making decisions for them. So, I'm lucky enough at Sick Kids that we have a pro bono lawyer to help us when we have difficult situations like this so that there can be sort of a neutral third party that we can refer to and there's no cost. But I do think it's really important that people understand that they have that option. Over and over again, that came up in the interviews that I did and the surveys, that there were concerns around this. So, yeah.
Are you aware of any plain language documents for people around that?
Yeah, so when you look at the resources, there's a really great document by the CCAC on informed consent that we've included, and it's a pretty lengthy booklet, but it's written in a very easy to understand format, as well. CLEO, Community Legal Education Ontario, I think I've got the acronym correct, also has a great little booklet on power of attorney and what it means, and it's in plain language as well. So those were the two resources that I felt were the CCAC one is more comprehensive and explains a lot of the ins and outs of this because it's a very complex topic because there's so many different specific situations that families and patients can find themselves in. And I felt like the CLEO one is sort of a short, quick guide, just specifically around power of attorney. So those were the two best ones, I'd say.
So in your work at Sick Kids, when you see an issue like that, do you refer to the lawyer? Do you have a social worker who works through some of these issues with people? Do you do that? Tell us a bit about the process.
Yeah. I think I'm spoiled rotten because at Sick Kids there's an interdisciplinary team. If an issue isn't really that urgent, we're often able to sort of step back and figure out who needs to be involved to support this family, what the issues are, how to break it down. You have risk management. You have your team with the lawyer who's there to act with the family. I try to bring in the right people with the right expertise to assist in those situations. So, and oftentimes my role, since I'm not as an OT doing anything that's very risky from a medical standpoint, it's often that I'm on the sidelines seeing some of these things play out. It's not necessarily my role and my professional designation going on to the note for consent capacity for certain treatment decisions, for example, like whether or not to do dialysis or anything that dramatic and big. My interventions are fairly low risk, so it's not it doesn't impact my direct work as heavily as it does some of the physicians that I work with. So yeah, usually you typically try to bring in as much support as possible. And if you're an independent practitioner and you're coming across really difficult circumstances like this, it's important to sort of seek support from your college to understand what your role is in these sort of situations, and also to sort of seek support from your employer to try and get more more people on your team that can help you if you're not sure what to do.
And we've also given a handout from today for legal services as well around all of these issues.
Exactly.
Thank you so much, Megan. I'm going to open, I'm just going to, before I ask people to start typing, these are the handouts for today, and we'll be sending them out tomorrow. And there's going to be the feedback survey, so we're asking you to do that. And I am going to open it up now for questions. And in case people don't have questions and are rushing off to watch the Raptors, that's what we're going to be talking about next Wednesday, personal support services at 7 o'clock Eastern Time. So I'm going to ask you to type any questions. If you have any questions, start typing. If you don't, that's okay too.
Well, I have a question while we're waiting, I guess, for Brendan. So in terms of power of attorney documents, like I said, we're fairly spoiled at SickKids and having access to a lawyer. Is the lawyer the person then, in this case, that has to determine capacity? And can these documents be filled out without a lawyer? Because I do see people, downloading the forms and trying to do them on their own on occasion.
Yeah, I mean, the documents can definitely be filled out without a lawyer. I don't know that I would necessarily recommend that, but the Attorney General's website has a power of attorney kit available, and I think I failed to mention that we do have the link on one of the slides in the presentation. But if you Google power of attorney kit, Attorney General, the forms will pop right up. But again, you have to consider the magnitude of authority that you're giving to somebody by signing these documents, and so you want to ensure that that you understand everything that's in there, that you understand when authority is going to be triggered, especially in the cases of property-related decisions. You want to ensure that your wishes, your specific wishes, are well documented. So it's often advisable to see a lawyer to put these documents in place, but you don't have to. If you are seeing a lawyer, typically the lawyer is going to, speak with you and determine whether or not he or she feels that you meet those capacity requirements to grant power of attorney. And if the lawyer thinks that you do, then they'll proceed with the document, and if they don't, they likely won't. That doesn't mean that there's any kind of binding decision that stays with you. You may go to another lawyer and they may have a different opinion, but if you do see a lawyer, they will typically go through a bit of an assessment process.
Thanks, Brendan. I have a question for participants. How many of you have actually worked with substitute decision makers around maximizing the person's ability to communicate with them? Or have you had some experience? Or if you have a question, please type it now. And what is your experience? That's what I'm asking. Oh, Rosemary, don't put your hand up, just type. Your hand is up. I don't know what to do about it. But if you can type, that would be great. Yeah, you're saying you have. Just wondering what your experiences are. I'd like
I can.
in the scope of practice for speech pathologists the same way as we'd like to see us do more with consent to treatment and accommodations in that context. Megan, I interrupted you.
Oh, that's okay. I can comment a little bit in terms of the interviews that it definitely people mentioned that, particularly speech and language pathologists mentioned having experiences with trying to improve the communication between the person who's acting as a substitute decision maker and the patient. I think it can be a really tricky role, and I think that it can also be something that you want as much of a neutral party doing that rather than somebody that's involved in the person's life in some way in some other capacity or involved in the healthcare team, so that there's no sort of conflict of interest as to what the influence could be there. So people felt some discomfort around the role of trying to do that sometimes, because of how complex these relationships are, basically.
And you're playing more of a role as a communication intermediary than as a
Hmm.
speech language pathologist.
Hmm.
Elaine is saying how that she has supported a person with communication disorder and substitute decision maker in ensuring the person. Oh, I'm so sorry. I have to lift this up a bit. Ensuring that the person understands and appreciates the outcome of any decision and has effective means to communicate a choice. So trying to maximize the person's ability to participate in that. Absolutely. That's more like what we were talking about last week. I have known guardians who have never even met the person that they are making decisions for, or I know of, not I've known them.
Hmm.
Gail saying, what happens if it's not possible to fulfill an individual's directives? Yes, that and Elaine says correct, and this gives peace of mind to both parties. Absolutely. So let's put that. What Gail's question, Brendan, Megan, what happens if it's not possible to fulfill an individual's directives?
I mean, I guess we'd have to know a little bit more about the context
Yeah.
here. I mean, this could relate to paying a person's bills, or this could relate to carrying out specific treatments with regards to healthcare.
Safety,
So some
yes.
context or some additional information would be helpful.
Mm-hmm. Mm-hmm. Just typing, we're waiting. Rosemary, did you want to type? You had said that you had your hand up, and I'm not sure if you're able to type in the chat box. Takes a little time for the typing to come through. And then I never know what happens when it just pops off for a little while. Gail is saying, I'm thinking if a person wants a particular living situation which is not available.
Oh, yes. This happens a lot. So what happens to many people is that they go on the wait list for, say, supportive housing in the developmental sector, which right now is, the Auditor General did a report, I believe in 2013, 14, and the wait list is like 25 years. So really the only way to get support the housing is through some of the crisis mechanisms, and a lot of the housing goes to people who are deemed alternative level of care in hospitals. And so many people will end up being placed in nursing homes when they've expressly said that they never want to end up in a nursing home. But the wait list for housing in pretty much every sector, whether it's attendant services, brain injury, Developmental Services Ontario, the wait lists are quite long. So that's an unfortunate situation, and I think that's part of why I work in pediatrics now instead of on the adult side, is because I feel like people should have the information about what types of options are available for living circumstances as early as possible to try and prevent that outcome from happening.
And that is what you're going to be talking about next week. You're going to be talking
Yeah.
about some of the personal support services for this population.
But that's sadly a very
The situation.
common
Yeah.
situation.
Rosemary, you are typing. Rosemary says, I put my hand up because my screen went blank with only the hand up and sound icon, so I just signed out and back in again. All right. Well, thanks for waving at us. Okay. Oh, that's no problem. That's no problem. I like that. It was a new icon for me. I was very impressed. So, if there are no more questions, I want to thank Brendan and Megan for the information this evening. It gave us an awful lot to think about. We'll be sending out the handouts tomorrow, and we hope to see you back here next Wednesday for personal support services, something completely different, or maybe it's not. So good night, everybody.
Good night.
Thank you. Good night.
Okay, Ellen. Bye. Bye, and go Raptors. Hey, I'm not even a big sports person, but I'm quite into this.
Oh, Barbara.
Enjoy the game.
All right. Bye, everybody. See you next week.
Goodbye.
Thanks, Lois.